We ready? I'd like to call the Rules and City Government Committee meeting to order. Please note for the record, members of the committee, Alderman Arnett and Alderman Chandlemeyer, are present. We're joined by City Attorney Mr. Lyles. I will entertain a motion to approve the agenda.
Motion to approve.
Second.
All in favor, please say aye.
Aye.
I'll entertain a motion to approve the minutes from the May 6th meeting.
So moved.
Second.
All in favor?
Actually,
please.
hold on, Madam Chair, I apologize. I was not present for the May 6th meeting, so I cannot.
I'll make that motion.
Okay, and I second it. All in favor, please say aye.
Aye.
Aye. Okay. First item, appointments and reappointments. AP 5522, the reappointment of Jennifer Beard to the Civil Service Board. What is your pleasure? These are all reappointments.
I've read them all, found them all quite satisfactory, although some of them I think should work in our Office of Social Services. So I would make a motion we approve all three of these reappointments.
Second.
So that's AP 55, AP 56, and AP 5722. All in favor of approving all three reappointments, please say aye.
Aye.
Aye. Okay. Before us is legislation 0622, medical cannabis dispensaries. And we've been joined by Alderman Gay, who is the sponsor of this legislation. So Alderman, I'll invite you to speak to it.
Thank you so much, Madam Chair, members of the committee. The legislation, as you see today, 0622, is very similar to 0420, which we discussed really in the thick of COVID, and obviously the election and things like that. But we did make tweaks, and the legislation this time around was also fairly supported. I think there were maybe one or two members of the
Council?
of the commission. I'm sorry, I was blanking on what commission it went before. Planning. Yeah, I was about to say Board of Appeals. Of the Planning Commission that had issues with it, but overall, it was supported by the members of the Planning Commission. They've made recommendations, which I've been willing to accept for the most part, as it relates to distances from schools, residential lot areas, etc. And we've also made, from the very, very beginning, every effort, despite legal advice, not to do so because we can't single out wards in legislation. We've tried everything we could to single out Ward 3. Right now, the current amendment is for a mile. The issue that we've had with the amendment, and the reason that I've gone back and forth, is because we're a very small city. And so a mile across anything, in particular when you're looking at the circumference of a circle in the area directly around the dispensaries, it didn't fit really. And so I'll be arguing the amendment once we have an opportunity to bring it to full council, just for the basis that I think, I'm not sure why we're discriminating against these particular business types as it relates to how many could be in the city and the distance between those businesses within the city. But that's something that I'm willing to discuss with the council, or also come to an agreement on, maybe half a mile or whatever the body would find helpful.
Alderman, there are 4 amendments, but before I speak to those, I'm not seeing the Planning Commission's report attached. Is it attached? I'm not seeing attached to our legislation.
I thought it in Granicus. I think it is.
I'm looking in.
I think not maybe in oh yes, under findings. I'm sorry.
Okay, I was looking forward to specifically indicate the Planning Commission. Okay, So in your 4 amendments, have you spoken to the 4 concerns by the Planning Commission?
So the mild dispensary buffer and 750-foot public and private school buffer was addressed in the legislation. Everything else that they recommended, the state already requires of dispensaries. No loitering signs shall be posted in all parking areas. Display and depictions of medical cannabis may not be visible to the general public. And the facility may not have an on-site physician for the purpose of issuing written certifications for medical cannabis. Those are primarily carried by the state, and the county really has also created language within their code, which we mimicked a little here as it relates to the distances between public and private schools. We did not include private schools in the bill as it stands, 0622, because private schools are different as opposed to the public school, where you can walk past a private daycare on a residential lot and you may not recognize that it's a daycare operating within a home. And so when we actually had the GIS map, it created some conflicts for us moving forward to allow the cannabis dispensary. So we decided against that, or I decided against that, I shouldn't say we, but we did include the public schools.
Okay. So your 4 amendments speak to, where are they? Speak to changing the distance from 2 miles to 1.5 miles.
Mm-hmm.
And speaks to changing the distance from 1,000 feet to 750 feet
Yeah, so the...
in public schools.
Yeah, and so as you'll see, an Amendment 4 strikes or private, which would remove the private school qualifications. Amendment 3 sticks to the residential lot lines and a public school, 750 feet as opposed to 1,000. And Amendment 2 is, Amendment 1 and 2 are really giving me leeway for the will of the council as it relates to distance between dispensaries.
Okay. All right, thank you. I've asked Mr. Lyles to be here, and I've asked the police chief to give me an update on, or a status on the dispensary, which seems to be at the center of concern. Mr. Lyles, can you tell us what legal requirements we have, or what guidelines we have from the state as far as controlling marijuana dispensaries?
The city has very few regulatory options with respect to dispensaries. The state, in the health article, specifically subtitle 13, subsection 133300, really lays out all of the regulations that are applicable to dispensaries. The one exception they make for local jurisdictions in the section is that it provides that the dispensaries, the growers, the producers, and all of the entities that have to be licensed and certified by the state must comply with local zoning and planning ordinances and rules. So your only regulatory scheme for these kinds of businesses is through your zoning and planning codes. Other than that, you have none.
Okay, thank you. Alderman Arnett?
To follow up on that, because I read there's 2 different ways that larger jurisdictions are handling this, and it does give the city, through its land use code, an ability. But if we didn't do this legislation at all, wouldn't the dispensaries just fall back to the state code? And I don't believe the state has these kinds of distances from schools. I certainly don't believe they have it for pharmacies or liquor stores, and I don't think they have it for schools. So if we didn't do this legislation at all, the dispensaries would be able to locate wherever they want, however they want. They could be next to each other. They could be concentrated.
Not necessarily. Your question is really twofold. One, since the state really doesn't do zoning like that, it's done at the local level, the county level, we're really talking about no regulation with respect to distances. However, there is a regulation with respect to the number of licenses for growers, processors, and distributors. And it is unlikely, based on the history of the state, that all of the licensors, producers, processors, distributors would get licenses for one particular area. The state is trying to manage licensing across the state so that these businesses are located in areas where people need them. It's unlikely that they would put them all in one jurisdiction or all in one state. As a matter of fact, they have the law, the Nancy LaPrade Commission law that was passed really kind of designates these things even by senatorial district so that they're spread out amongst the state. So
May I try it a different way? One of the things this legislation does is to make it a permitted use in our Title 21. But I would argue the state has already made it a permitted use. So do we really need to go to the extra effort of making this a permitted use and designating subject to standards and those sorts of things?
Well, the state hasn't made it a permitted use in the zones you specify because there is no such state zoning law.
So it means it's permitted anywhere.
I don't see it that way. I see it more so relying on the local zoning. For instance, a city or a town or a county that is 100% residential would probably, the residential code would probably prevent these kinds of things from going in there because the understanding of residential is that there's no commercial. So it's, you pretty much go through the door of zoning at the local level anyway. So if you have zoning laws on the books at the county, city, or town level, that exists to regulate them first, right?
So that answers the first part of my question, which is we need to put into code that this is a use, first and foremost, because it's not a use in current code. And secondly, where it can be used and where it can't in terms of zoning classifications. So it allows it in business classifications, PM, so on and so forth. And then it further stipulates subject to standards. It's that last one. If we didn't make it subject to standards, it would just say you can sell this medicinal cannabis anywhere you can have any other retail activities.
Yeah, what happens, especially in Annapolis, is that when something doesn't have a designation or a use, and you're spot on, you have to establish it as a use first.
Right.
And then it goes, without that, planning staff would have to figure out where it goes. Is it retail, for instance, or is it light industrial? And they would fit it in without a use, without it falling in the use table. They fit it into something else. It is more appropriate and more of a rational exercise to actually designate these things as something so that planning staff don't have to fit it in, and then decide where you want that use to be permitted or by special exception or what have you.
Right. So we do that on page 2 of the ordinance, where we amend the use table and we add medical cannabis dispensary as a use in the B1, B2, B3, B3CD, BCE, BR, C2, C2A, PM2, and Industrial 1. And in every case, it's permitted subject to standards. Then we also make the addition to the use table for the mixed-use districts. And again, we make it subject to standards. So that satisfies as far as we have to go. The next part of the code, though, then goes to the standard section, 2164, and that tells the land use staff, the planning staff, what are the standards. And that's the amendments that Alderman Gay is proposing to us. Then we have the definition section, which there is another amendment proposed by the planning staff and the planning commission, which is that we amend this to conform to the state definition of the medical cannabis dispensary. And I think that's a minor change. So, all right, I think you answered my question. We do have to do something legislatively to make it a use. Once we make it a use, we have to say, is it permitted? Is it permitted subject to standards, et cetera, et cetera. So thank you for that.
And I would also add, Mr. Alderperson, that you should probably include processors and growers, since those are businesses as well attended to this particular industry. Processors and growers might come along, and they're different than dispensaries under the state code.
Well, let me ask about processing and dispensaries. If my memory serves me correctly, the state chose where growers could exist. And we don't have any agricultural areas in the city, I believe, where growers could exist.
Well, potentially, you could grow it in a building. You don't need a agricultural facility. As a matter of fact, the growers that I'm familiar with all have a facility. It's a building that they grow these plants in.
Like a warehouse, you're
Yes, it's
saying?
not outside.
Okay. Show you how much I know.
But technology will advance enough where you could grow it pretty much anywhere, in or outdoors. So, the law should address, in my view, wherever they can go, because there's no size requirement to the farm for a grower. It could be on an acre, and there are some 1-acre properties in the city. So to the extent that these businesses could come along, you might be well poised to add growers and processors as a business in the zoning use table.
Thank you. Alderman Gay?
Thank you so much, Madam Chair. And to the point that the city attorney made, I would completely agree with the grower and processing point, as that was something that I was thinking ahead towards. But if it would make more sense to add it here, I'd be open to that. And particularly as it relates to, I've mentioned to the mayor a couple of times, Waterworks Park, which is not all used for recreational activities. Obviously, the solar grid is there as well. And I'd be interested at some point, in particularly if the referendum passes in November, which with 70% of Marylanders supporting the use of recreational or medical cannabis, I completely believe that it will pass. It may be an opportunity for us to even lease out, ground space there to potentially bring in revenue through the growing and processing, growing and process. But I think, and that's the second thing that I've harped on throughout this entire, since even 2020 when we had the initial bill, the revenue that can be created through allowing the dispensaries, through allowing the growth and processing is crazy. When you look at some of the smaller cities in Colorado, LA, etc., when the state legalizes, they also create laws within their individual municipalities for transfer, processing, etc., which creates a lot of revenue. And so that's an avenue that I was looking at as well. But my question is, I'm wondering if and I'd like the city attorney to weigh in as well, if the committee would sponsor an amendment, or I would be happy to put the amendment in, as a recommendation of the staff report. If you look at the last page, or page 5, I'm sorry, it says staff is also recommending that the definition of a licensed premises of a licensed dispensary of medical cannabis be amended to the state the following. A licensed premises of a licensed dispensary of medical cannabis is as defined in Comar 106201.01. This change will allow, if there are any changes to the state law as a definition, it will not require the city code to be amended. And particularly with the referendum looming, I'm wondering if that would be worth it, but I want to check with the city attorney first to see if that would be the best way to move forward.
Alderman, could you repeat which section you're talking about
Yeah,
on page 5?
Page 5, the second paragraph, the commission made a recommendation to change the definition of a licensed premises of a licensed dispensary of medical cannabis
Got it.
to match, I believe Comar, the 106201.01 is the state verbiage, if I'm not mistaken.
So you're asking the city attorney whether it would be prudent to amend this legislation to include the definition of a licensed dispensary?
I am, because I'm, as I said earlier, I'm confident that the referendum will pass, which obviously means, as we've seen in other states, a referendum passing doesn't mean weed is automatically legal.
Right.
It takes typically a year for the rules and regulations to be created. But I'm wondering do we get ahead of that by changing the definition to match the state definition, or should we wait until November to see what the results are?
Given the nature of this particular industry and the inability of the state and the state law to be clear, and a lot is still left undone, I would not follow behind the state. In my opinion, I would not follow behind the state right now, because even the legislation that we're discussing today at the state level, there's still a lot left open. Like with respect to the following or complying with zoning and planning ordinances within a local jurisdiction, what does that mean, really? Especially if the law of the city or the county decided to outlaw it totally. Could a local jurisdiction do that? And it's really unclear in the state law whether that's even possible. But it would seem to be possible the way they wrote it. So I think there's so much left undone at the state level that I would like to see more definiteness and concrete language in a lot of places before we just say, let's follow whatever the state does. I think waiting is a better option. If we need to change it, we can always do so. It's not very complicated to do that in our code.
Thank you. And Alderman, you mentioned the fact that even though it may pass at the state level, it will take some time to implement it. So that would give us adequate time to change our code.
Absolutely. Even with this, if this was to pass, as the city attorney mentioned, the state handles and designate licenses. There's been rumors that they will lift the cap to include more licenses. They were at maximum capacity, I believe, when we originally discussed this legislation, but I believe there may be an additional license available. And I've been talking with the same professor that we had come before the committee, who's well-versed in the business and has, friends and former colleagues in the business, as well as the Maryland Cannabis Commission. They have legislative aides and reps that we can get in touch with. And so I think there will be a space for us to get involved in this and to, reap the benefits as it relates to revenue.
Well, there is still one issue that hasn't been resolved, and I'm not sure how any state is addressing on the banking portion of it, since the federal government still does not recognize it. And from my understanding, these businesses cannot use traditional banking methods. So how are we getting around that portion of it, and do we have to be concerned about it? I mean,
It's not our problem.
it's not our problem.
I was going to say I would defer to an expert in the banking of cannabis.
Well, it lends another level of security to the businesses if they have to conduct businesses cash only, or however no, it's not cash only.
It's cash only. And that would be potentially a zoning or planning issue.
Okay, so we don't have to be concerned about it. Alderman Chenoweth, I'm sorry.
Thank you, Madam Chair. So in regards to the banking systems, I think banking and cash storage regulations are a little out of our purview and ability to regulate
Just a little.
as a local government. The states that have legalized this, despite the federal prohibitions against making this like a fully streamlined business process. The other states that have done it, such as Colorado and Maine, haven't seen these massive issues, even without heavy regulation from the local government. While it is cash only, if someone is getting into this business, they have to have an understanding of that. And I think if we try to put in restrictions for how things are stored here, for how money is stored here and there, we're getting a little into areas that I don't think local government should be getting involved with. It's up to the business owner if they want to create it. It's up to the business owner for how to keep their money safe.
Okay. And so what is Alderman Arnett, sorry.
Yes, thank you. So I do have some problems with the staff report, wherever it got off. I'm not sure I subscribe to the recommendations. They say a key finding was that the discrimination continues to occur against women and minority-owned. That's fine with me. But where they say the purpose of the Planning Commission is to stop concentration, I'm trying to find the page, of these things and spread them thinly, I don't understand the discrimination against medical cannabis, now we're talking about, versus drugstores or liquor stores or any other kind of retail. We don't have anything in our code that specially says that we need to prohibit drugstores to 1 every mile or liquor stores 1 every mile. We do not allow, I believe, liquor stores near schools and churches, so you can argue with some of that. But I think there's a little overstepping here. I think it's up to the free market to determine the concentrations and locations of this, as long as they're following the use prescription that this code has. So, and I question some of the other things that they sort of assert, where are my question marks, as things that are basically city policy. It has to do with the, I can't find my question marks. Primary goal of the Planning Commission is to prohibit clustering of medical cannabis dispensaries. Why? And to assure approved dispensaries are spread thinly throughout the city. Again, I don't understand why that's their primary goal, but we're the policymakers. There are only 9 policymakers in the city, and I want to make sure that we're not subscribing to that as our policy goals, because I don't subscribe to that. I think that's a market force issue. So that's a general concern I have about the Planning Commission recommendations. And so that speaks to the distance from existing dispensaries. why are we concerned about that? There are 4 recommendations: distance from existing dispensaries, distance from public and private schools, distance from residential lots, and the other one was that the dispensaries not be available to public view. Here it is, it's on page 6 of the commission report. The 4 recommendations, the mile, and I think Alderman Gay, you have 2 different amendments on this. Amendment 1 is half mile, and Amendment 2 is a mile. I like half mile. I don't even understand what is 750 feet, 1,000 feet, 500 feet, 0 feet from schools, but then no loitering. So you can loiter at a liquor store, you can loiter at a pharmacy, but you can't loiter at a dispensary? Is this a big problem? Can you loiter at Royal Farms, but not at a legal medical? So there seems to be these built-in pejorative biases in these recommendations that are not substantiated with any rationale. Displays and depictions of medical cannabis may not be visible to the public. Like we're keeping it a secret. It's legal. It's the state has made it legal. So I don't understand. We can have cigarette ads, but we can't have medical cannabis. And then this last one, I don't even know that we can control this. The facility may not have an on-site physician. How do we control that? So it really does feel to me like there's a very paternalistic and pejorative attitude towards this. It reflects again in the petition we received on Monday night, which I don't think discriminates between medical cannabis and recreational use, but there seems to be this bias, which when the state makes recreational cannabis legal, is going to carry over into more codes and more not in my ward kinds of attitudes. And I question the fundamental psychological or philosophical approach that the Planning Commission and the planning staff are setting forth in this report. I think it's not what I subscribe to, and I do think that is the 4 of us plus our 5 other colleagues that actually get to set forth those policy positions and or biases, if you wish. So I do have some fundamental things. I only have one more point to make, and that is I do think if we go to page 4 of the legislation itself, line 7, and say subtitle 33, that grows, comma, acquires, possesses, and so forth, that we can cover this possesses or grows thing in the definition section in 2172, just simply by adding the word grows. So that's
Would
fine.
you like to make that as a
Well,
motion to amend?
I would, but I saw Alderman Schneidermeyer raising his hand, I think, to respond to some of the things I said.
Well, we could get it on,
All right, so I make a motion that the Rules Committee add an amendment to this
06.
0622 on page 4, line 7, after that, insert grows, comma.
Okay. So it'll read medical cannabis dispensary means an entity licensed under the Maryland Code, Health General Article, Title 14, Subtitle 33, that
Grows,
grows,
acquires
comma,
possession.
acquires, comma, possesses, comma.
Excuse me,
And so forth.
the dispensaries don't grow. Dispensaries dispense, growers grow, and processors process.
Well, then we have a different problem with this definition then, because it does have process. It has transfer, transport, sell. So I think that's part of the reason why the planning staff said, let's just stick to the Comar definition of medical dispensary and not have all this other verbiage. So think we
Yeah.
need to do it one way or the other.
Yeah, I didn't read all of that, but given that change, the Comar definition is probably more appropriate. I didn't know that our definition is veered so far from the Comar. Because if you just say medical dispensary, there's a statewide definition, and just that's all you need to say. You don't need to define it again.
So that goes to the planning staff recommendation to the planning commission. On page 5 of their report, staff is also recommending the definition of a licensed premise of a licensed dispensary of medical cannabis be amended to state a licensed premise of a licensed dispensary of medical cannabis is defined in Comar 10.62.0101. And that makes our definition consistent with the state definition.
So, was there a second to the Alderman's motion? No.
No.
So it can die for lack of a second.
Right?
Okay. And that takes us back to the original, but if we want to follow the staff's recommendation, then we still need another amendment. Alderman Gay?
Thank you so much, Madam Chair. I'm wondering if it may just be appropriate to leave the definition as it stands without adding grow, because dispensaries do possess, at times they do process, they definitely transfer, transport, sell, etc. All this defined here. So I'm wondering, would it be fine to keep that, or should we actually pull up the verbiage of Comar 10.601 and compare the two?
Well, the only issue I had with the definition was grow, because grow has a definition in the state law. So if you take grow out, it makes it more legally
It is out.
sufficient.
So should we
So
just,
my motion died for lack of a second.
should we bring grow back later?
If you would want, yeah, but to not put it in as an amendment here.
Yeah, okay, I'm fine with,
Yeah.
if that's okay with the city attorney as well, bringing it back at some point. I mean,
Well, if you send it back to my office, we can have a conversation about it and make sure it's correct.
okay.
Because I don't remember reviewing that particular section for definitional purposes until you just said the word grow.
Okay. I'm sorry, Alderman Gentlemeyer.
Ignoring me.
It's the right side. Now I know why the mayor always misses me when I raise my hand down there. So, Mr. Laws, I'm going to count on you to keep an eye on my hand down here, because there's something about not seeing the right side.
I'll start doing
Yes, ma'am.
this.
That's what
I just wanted to add something for.
Notice the women sit on the right side.
the women are always on the right side. What's wrong with you?
I just wanted to piggyback on Alderman Arnett's comments on us treating dispensaries differently than other businesses. I really am in full agreement. I understand that there are some folks who have a moral or leftover legal objections to this substance, but when you look at actual data for its impact on people, on cities, on populations, marijuana is so much less harmful than other substances that are both legal and illegal, and including medically prescribed substances, the biggest thing being opioids, which medical marijuana is a fantastic alternative to. Even throughout all the opioid epidemic, we didn't put any kind of restrictions on pharmacies that could prescribe medical opioids. If people are consuming medical marijuana, it has been offered as a prescription. We can get into the nuances of full-on legalized and recreational if and when the state law passes it, but this is a medical licensed facility. And I would be inclined to agree with your assessment that putting more restrictions on one type of medicine is the city council passing a moral judgment that was flawed to be implemented at the beginning And we owe it to ourselves and to our city to be standing forward that we care about actual data. We care about forward-thinking policies, not flawed assertions of the past. So I will share my colleagues' agreements that treating this differently is a little bit silly.
Ill-founded.
Thank you. I shared with you what's, I think, tantamount to a white paper from Major Stan Bradford from APD. I guess it was a couple days ago, I made a request to the law department, our police chief, our fire chief, and our planning director to provide us with data about the current facility, because that seemed to have been the model that's under attack. And so I'd like to add this to our record, but just to summarize briefly, he speaks to the fact that there is 24-hour, 365-day surveillance at the facility that is detailed to the point to identifying facial recognition, having facial recognition. He speaks to the fact that one can have as much as 4 ounces of dried medical cannabis or 36 grams of THC infused in products. And right now, cannabis cannot be consumed in public. It must be consumed indoor or on private property. And it is a civil offense, not a criminal one, and a person cannot be arrested for such possession. And lastly, the city of Annapolis has had no calls for service from the Gold Leaf dispensary on West Street. There have been calls by the county, since that does sit in the county, but there, and he says a wide range of calls since 2012, when the dispensary, I think, opened. And he did note, and I will note, that that area surrounding the dispensary, for as long as I can remember, has been a hotbed for all kinds of activity. And so I would be interested, if we're going to have to belabor this, to identify the difference between other illegal acts going on there and actions that are attributable to the dispensary. And I think that would be very difficult to delineate. Alderman Gay?
Thank you. If I could also add, our former colleague, Fred Payon, who at the time when we introduced it in 2020 also reached out to the state's attorney's office, and they were unable to trace any crimes at all directly related to the Gold Leaf dispensary on West Street.
Mm-hmm. So thank you. So for the record, I think we'd like to attach this. Alderman Channemeyer, I see you.
Sorry, I couldn't resist. I think that would actually go pretty hand in hand to statistics that we've seen in other jurisdictions that have streamlined medical dispensaries or even recreational, full-on recreational dispensaries. My birth state of Maine legalized it statewide, and there was no significant or any noticeable impact on crime statistics. So I understand why people may have that concern, but this again comes down to, do we want to make our decisions based upon documented data or on concerns without numbers to back it up? I usually try to come down on the side of data.
Thank you. And I think that is where we should be leaning, absolutely. So thank you. Alderman Arnett?
Madam Chair, I move that the committee recommend favorably on Gay Amendment number 1.
I shall second it.
Okay, further discussion? Hearing none, all in favor of supporting Amendment 1, the Gay Amendment, please say aye.
Aye.
Okay, Alderman Channemeyer.
This would be a point of order question then, Madam Chair, because I believe amendments 1 and 2, unless I'm misinterpreting this, would come as in conflict with each other. due to distance between dispensaries. Do we want to
Recommend unfavorably amended.
give it an unfavorable recommendation instead of skip it over, or? Okay. In that case, I would like to make an unfavorable motion on Amendment 2.
Second?
Okay, further discussion? Hearing none, all in favor of opposing Amendment 2, please say aye.
Aye.
Madam Chair, I would like to ask the sponsor a question about Amendment 3. Even 750 feet is 2.5 football fields.
I had 5, but I had 500. But because the county had 1,000, I felt it would be appropriate to kind of meet my colleague from Ward 3 in the middle with 750. My problem with both private and public school regulations and requirements.
That's 4, we're doing 3 now.
Yeah, on 3, yeah, which is the residential and the residential and private or public school lot lines. My problem with those requirements are that, for example, if you look at Annapolis Middle School, which children from my ward attend, the kids have to walk past a liquor store, not only advertising, blanketly showing, I mean, it's the only sidewalk to get past. And so the requirements to say, okay, these particular businesses, which we've already, I mean, we know Gold Leaf, we know even the one in Edgewater, it's so secure, you don't see any signs of cannabis, maybe a pun on the name, that's about it. There's no smell of cannabis. We've just realized that we talked about the discussion of lack of crime attributed directly to the dispensaries. So I'm not sure why the requirements are in for school or residential lot line requirements, but I thought it was an effort of good faith. In my personal opinion, I do not believe that it's necessary to have. Just looking at the data, I think the only dispensary that I'm aware of that actually was robbed or had any issues was in Baltimore off of Charles Street, North Charles Street, if I'm not mistaken. That's the only one. And I desperately tried to find stories on all of this. So that's my argument for the Third Amendment.
So what is Alderman Schoenemeyer? I'm going to sit back so I can see.
Thank you, Madam Chair. The quick question for our law office, or any of my colleagues, if you know the answer to this as well. For Amendment 3, do we have similar rules for other pharmacies for separation from residential lots?
We do for liquor stores.
I don't know for pharmacies.
Do we for
Although
liquor
we
store?
do have other than in a mixed-use zone, we do have clear designations and distances between residential and commercial districts.
Okay. Do we have that for liquor stores?
I don't know. I'd have to look.
Would I be being that guy if I ask us to look that up?
I think I do remember something about liquor stores, but I couldn't say with any certitude. That's the only thing I can remember, and it had to do with schools and churches, if I recall the code correctly.
I do definitely think, though, there is a very valid point to pointing out that children from Robinwood and children from Annapolis Overlook, which is part of my ward and where I used to be a resident of, they do have to walk past a liquor store, past gas stations, things that are already mind-altering or industrial in scale. And I think any harm that comes from those walking past has less to do with what products those things sell and more to do with the fact that they're big strip malls next to a urban highway. So I would be inclined to agree. I am just personally curious about what the liquor store versus pharmacy or medical cannabis dispensary rules would be. because I do think those are a little more fair comparisons in some ways, but
Ms. Green, can you look that up for us in the code?
We need to have
See
a
it.
copy of the code here.
If I could, just going off of memory, and I also pulled up muni code here. As the city attorney mentioned, he was spot on in saying, I'm not aware of, and I'm looking here, and just even in my discussions over the last 2 years with staff, of any particular distances required. But there are obviously zoning regulations that may prevent like liquor stores or whatever being near residential areas. All of the personal care, which also tied into pharmacies, was zone P, S, T, D, I believe, which were in much more regulated areas. I think they were only in a few spots throughout the city, and that was shown on the original map as well. But I don't believe there are any actual distances. I just know what the zoning code is showing right here.
It would be, I could look it up, but I can't look it up at this point, but we could definitely supplement the record with information. But zoning really doesn't work necessarily like that in the current configuration. You have zones, but you have commercial zones that back up to residential zones, for instance. And now we have mixed use, which is a predominant zone in a lot of areas across the state, county, and in the city, where you have commercial mixed in with residential.
So here's where I'm kind of coming from this point. I don't think I've made it any secret of my love of mixed use zoning and my belief that everywhere, with the exception of industrial, should be mixed use. So in my opinion, I don't think those separation lines should exist. So I am a little more curious about this specific boundary point for some other stuff. But I will not delay debate on this amendment due to my ideological views on Euclidean zoning, and I will make a favorable motion.
You're making a motion to
A favorable
support amendment
Yes,
3.
favorable recommendation. I
I'll second
apologize.
that. Well, I may
Further
want to have more
discussion?
debate when we get to the council meeting.
Okay, so we're on amendment number 3, and the motion is to give a favorable recommendation.
Yes.
Further discussion? Hearing none, all in favor, please say aye.
Aye.
And amendment number 4. What is your pleasure? Amendment 4, strikes or private, meaning private schools. Alderman Gay?
Thank you so much, Madam Chair. And if you look at the attachment, 1, 2, 3, 4, 5, only 5 private schools would be affected. And again, the reason I had to strike or private was because a lot of these are close to either commercial or residential areas, and the 750 feet, while it seems insignificant, is significant when you're looking at, again, the circumference of the map, of the circle from X point of business. And it just didn't work well.
Alderman Arnett?
So, Madam Chair, I'm not sure why we're doing this for schools at all, but if it's a school, particularly given what the Supreme Court just told us, that we're eliminating the separation of church and state. A school is a school is a school. So on this one, I'm not favorably inclined. I would rather get rid of the prohibition about nearness to schools altogether, because I really don't, particularly, again, I think the underlying animus towards this is everyone is looking forward to legalizing recreational drugs. I'm probably going to have the same opinions on recreational cannabis that I'm having on medical, but maybe there you can stretch and say, kids could sneak out of school and go over, and the proprietors would be so stupid they wouldn't recognize that it's a minor and they would sell them the evil weed. But I on this one, if we're going to keep these things away from schools, I would think we would want to keep it away from all schools.
Alderman Chandler?
Thank you, Madam Chair. This is a little bit of a trickier one, but I think for the purpose of viewing this in a medical light and debates about the legitimacy of how stringent the medical definition is, we can leave to powers other than higher than I. But since we are defining this as a medical thing and we do not have the same restrictions on pharmacies, I understand not wanting to kind of keep consistent with public and private schools, a school is a school is a school, but this would give more leeway that we ideologically align with, even if it conflicts with that other definition and idea. So I am more inclined to be in favor of that flexibility to give, where identify with a little more ideologically, where these are, as law currently states, a different kind of pharmacy. So I would be in favor of this. Since, and if I am putting words and ideas in your mouth, Alderman Arnett, please correct me and I apologize. Since it seems that you are leaning against this amendment, is that a correct interpretation? And I am leaning...
Actually, I'm leaning against this section of the standards, period.
Yes.
But,
And I have a point,
Setting that aside.
Madam Chair, when you're ready.
Mr. Lyles?
Also, the state health article also provides or allows for the administration of medical cannabis during school hours and events. So it relies on the commission to create regulations that guide schools in providing medical cannabis during school hours on school property. So the state is already conditioned to the fact that medical cannabis may be administered to children in the school building, on the school bus, during school hours on school property. And they have to develop guidelines and regulations for that. That's section 7-446 of the health article.
So what you're saying, Attorney Lyles, is that because the state allows this as a medical purpose, there is state regulation for medical consumption in any form on school property?
Yes, I'm saying that because there are laws that restrict and prohibit marijuana and cannabis already, because marijuana and cannabis is only decriminalized as it relates to proximity to a school, possession, use being the main drivers. With respect to whether or not cannabis in various forms is allowed near schools, the point I was making was the state already allows it in the school building because it is a medicine, but the control of it is subject to their guidelines. But possession and use near the school, on the street, is still regulated by criminal law anyway. So even though there's a slight tension and conflict there, the state does recognize it as a medical use and allows it inside the school, so that if there is a law that the city passes that has a concern about proximity to the school for the business of dispensing to people that are licensed by doctors to receive it, it's apparent that the state has already seen that that's not a problem, since they allow it in the school building. And there are controls on criminal use and possession in and near schools anyway, because marijuana currently is still a Schedule I drug in the United States.
I'm going to yield my time because I believe the bill's sponsor, Alderman Gay, has a comment or question.
It's just about to recognize.
No question or comment, or no question but comment. Just saying how genius our city attorney is. I actually forgot about that, and he is actually right. I'm so pleased that you brought that portion of the state code up. It is allowed and administered in school facilities, and I believe it's up to the individual county to create the policy, if I'm not mistaken. I know in Anne Arundel, the school nurse is able to administer within the building. There can't be another child within the office, but they can do so. Obviously, it has to be oral or atopical in the school, you can't smoke it, but they do allow for the use of medical cannabis. Thank you so much I completely forgot about that.
So does that negate the need for Amendment 3?
No, because it's two different kinds of use. Dispensary is a use, and then there's the use of the products that dispensaries dispense. So I don't, you can use medical cannabis in schools. That is not the same as what we're doing in code, where we're talking about the dispensaries as a use in the zoning sense.
Okay, Alderman Gay?
Thank you so much. If I would, I know I introduced this amendment, but now I'm arguing against it. I'd argue that this be an amendment for recreational use, for the reasons that both the city attorney stated and my colleague just stated. The medical cannabis dispensaries, as we know, are like lock and barrel. You couldn't just walk in and purchase without the appropriate identification. So I think that prohibits any idea of our youth like actively going to a dispensary and seeking out cannabis. If this was to pass recreationally, obviously then that's something where we could go back and say, okay, recreational facilities may not be allowed within 1,000 feet of school for easy access. But again, I'm with my colleague from Ward 5 on this, that when it's for medical reasons and medical purposes, I don't see the point in discriminating in regards to distance from residential lot lines or school lot lines.
So let me ask the question again. That's Amendment 3. What do we have a favorable recommendation, but is it necessary for medical marijuana
So
dispensaries?
to me, Madam Chair, there's two different things going on here. One is public schools versus private schools.
That's
The other-
Amendment 4.
The other that we're talking about now, Alderman Gay, is should we be mentioning around schools, period, public or private? That's a different amendment. That would be an amendment to drop lines 42 and 43 from the ordinance.
Well, we already gave a favorable recommendation to Amendment 3, which spoke to the distance around the school.
Right.
So that was my question. Are we prepared to stand on the support of that amendment?
I'm sorry, I interrupted.
Or what would your option be?
While we try to figure that out, like to reopen, or whatever the terminology is,
We could reconsider.
reconsider it and then just make the new consideration no recommendation?
Second.
Yeah.
Would that be the best
So the
process?
motion to reconsider the support of Amendment Number 3.
Motion to reconsider, seconded.
Okay, it's been properly seconded. Further discussion? Hearing none, all in favor? Aye.
Aye.
Okay, so we've obliterated Amendment 3. Do we want to take a position in opposition to Amendment 3? Alderman, is Amendment 3 going to move forward?
3 or 4?
3, we're on 3 still.
Okay.
3 is the
All right.
distance. Then we get to 4, which is the private school versus. So are you planning to withdraw that amendment?
I just for a point of order, are we on 3? I thought we were on 4.
I thought we were too.
We've reopened, we're reconsidering Amendment 3.
Oh, okay.
Because that was the one that dealt with the distance.
Okay, perfect.
From
Yeah.
the dispensary.
My personal opinion is that I do not believe that either 3 or 4 are necessary. I think that with the state regulations, some of the county regulations, which I assume that we'll rely on if there are missteps, I don't believe that either residential or school properties will be affected by removing the requirements for 3 or 4.
So the answer is that you plan to withdraw those amendments?
I plan to do whatever the body wants me to.
Mr. Lyles, what step, okay, Alderman Chandler.
Since the sponsor is, I apologize if I'm misinterpreting this, unsure of the necessities of Amendment 3 or 4, but not committing to withdrawing them, I personally believe the prudent action and the time-saving action for this body would be to make no recommendation on Amendment 3 and no recommendation on Amendment 4.
Well, thank you, but I didn't hear quite the same thing that you heard.
Okay, then.
I would like to give the sponsor the opportunity to, where's he going?
Where is he?
Phone call.
Well, I think the problem you have with, if I might, Madam Chair, with respect to 3 and 4, is they're trying to change things that are inserted in the bill today. So maybe, and what I'm hearing is that you don't want any distance requirement at all, but there is a distance requirement in the bill. 3, modify the distance requirement. 4, there is restrictions to schools, and 4 modifies it. So what I'm hearing is that you want to change the bill. This is an Amendment 5 that would eliminate distance requirements in feet and yards, as well as distance requirements from schools. Just strike those out of the bill as written.
I'm not sure the need for an Amendment 5,
Okay.
because these are his proposed amendments. And I'm sure we're the first body to respond to them, but if he withdraws them, which I think he can do.
If you withdraw 4, you will have a restriction near public and private schools, because that's in the bill as written.
Well, I'm asking the sponsor, what is his pleasure? If he's not interested in Amendments 3 and 4, then we don't need to act on them, I don't believe.
I think what the city attorney just stated, which I overlooked, is probably important. The Amendment 4, which again, I'm at this point really in support of, could be removed, but we'd also probably have to go into the legislation and actually remove the 2 lines that state the restriction. So that would be
Lines 42 and 43, and that's what the city attorney said while you were gone. We could take no position on your amendments 3 and 4,
Yeah.
but we could, as a committee, offer an amendment of our own, which says to drop lines 42 and 43.
I would be in favor of adding that amendment if it was, and I'm sorry, I had to step out really quick.
Okay, so Amendment 3 and 4, we're going to take no action on them.
Right.
And then Amendment 5,
Well,
which
it would be rules
which would
committee.
be the Rules Committee Amendment 1,
Right.
would be to eliminate page 3, lines 42 and 43 altogether.
Second.
Second.
Second? Okay. Sorry, I thought you had made the motion and Alderman
I know,
Burnett had seconded it.
no, the chair is not making the motion. You
All right, so
guys have to
I
make
make
the
that motion.
I
The
shall
Rules
second.
Committee recommend dropping
Okay.
lines 42 and 43.
Okay, and it's been properly seconded. Okay, so that would not be Amendment 5, but Amendment 1 for the Rules Committee.
Correct,
Okay.
Madam Chair.
Okay. Further discussion? Hearing none, seeing none, all in favor, please say aye.
Aye.
Aye. Okay. Now I will entertain a motion to give a favorable recommendation for 0622 as amended.
So moved.
Second?
Okay, and those are the 2 Alderman Gay amendments and the Rules Committee amendment.
Correct.
Okay, it's been moved and seconded. Discussion, Alderman Gay?
I just have a quick question about the actual process. I was informed earlier that the administration requested to have it removed from the agenda on the 11th because of, I guess, the amendments. Now that we have an understanding of the amendments, can it be put back on the agenda, or?
I was informed the same thing. I wasn't here this morning for agenda review. However, it wasn't ready for this Monday's agenda anyway, because it actually has to go to economic matters as well. Apparently, that it was requested at one of the city council meetings.
Who chairs that committee?
As chair of economic matters, do I have the power and authority to release it? unilaterally, or do I need to take that up with the rest of the committee? Because if you want to get it in front, if you want to get it in front of the council at large, like I'm gonna vote the same.
I'm fine
way.
with whatever, but I just figured I've talked to my colleagues. I'm sure that it'll pass. We've got the amendments. 11 would be appropriate to vote on it, but if there are concerns from all law as it relates to putting amendments together, I'm fine with waiting.
I mean, we get it for economic matters. We're meeting on, I want to say the 13th. Is that correct? The 20th. So that would
Put it on the 25th.
put it on the 25th. If I have the power to unilaterally release it from the committee, let this be my motion to do so.
Alderman, what does that mean, release it from the committee? I don't understand.
Does it have to get a hearing in economic matters?
It does not have to get a hearing, but I would caution doing it in this manner. As a technical process, you want to avoid confusing the public. The public thinks it's going. If there's a meeting and as a committee, you decide not to hear it, you can do that, but you probably want to do that in public in a way that lets the public know what your decision is. Doing it in this meeting is probably not appropriate, given that the public would not know it. And so I would augur or recommend that it stay on the committee's agenda. When the committee opens its meeting, it can decide not to review whatever it's going to review in the context of that meeting, thus putting it on the last meeting in July, putting 0622 on the last meeting in July.
I will talk to the bill's sponsor and we'll figure out a plan.
And you can pull the rest of the committee members.
Yeah.
Who are the other members?
Alderman Gay and Alderman Savage.
And Savage.
Yeah.
If there's some other way we can figure out how to do it, we'll let you know. But the problem is the public notice. The public was apprised in a meeting prior to this one, public meeting at the council, that it was going to get referred to a committee. And so individuals who might want to come to that committee and hear it or speak at the committee would be waiting for it if they couldn't make this meeting. So you'd have to let the public know at some point in advance it won't be heard by that committee.
All right, that's a fair point. I'll connect with you and some other folks to see the best course of action. Thank you.
Well, let me ask the question, could not there be an announcement that the the Economic Matters Committee agenda has been amended to remove this item?
And that's what I was suggesting to look at, to make sure that it was appropriate and that there was fair notice to the public. The question becomes, what is the form of that? Because I've never seen it done. So what is the form of that? And then how much time do we have to alert the public to that? What might be reasonable? And then give us enough time to put it on the agenda for the 11th. I'm just trying to figure it all out from a process standpoint. Of course, those with more history on the council who've seen that done, you can let us know and we take a look at it.
We can have that discussion after this meeting offline.
Committee assignments or committee recommendations are just that. They're not required. But the city attorney is absolutely correct. The public needs to be notified. But the committee can decide not to hear it and let it go to the full council. And that's perfectly fine.
Exactly. So it's about notice.
Yeah.
And how do we get to the notice? And is it in time enough to put 0622 on the July 11th agenda?
Okay, now that we've solved your problem. Let's see. The next item on our agenda is adjournment.
So moved.
Second?
All in favor, please say aye.
Aye.
Thank you very much. Good meeting.
Happy 4th, everyone.
Happy 4th. See you at the parade on Monday. What time is the parade? At 6 o'clock?
6 o'clock.
6 o'clock. Okay. We'll be there. You doing the parade?
Nope.
You never do. Well, that's not true. You did.